All right, going to kick this one off. We'll do the lecture stuff first, and I'll do the test stuff at the end. We want. Oh, that's a bit scary. YouTube. Okay. How many we got? We've got about, I'll round up and say 25 people here. Good job. Good job. You made it. And not quite at the halfway point of the semester. But we have turned the tide in terms of the material for your semester test. So this stuff, in theory, again, I haven't seen the test, but in theory, you're not going to be assessed on the things in here. So while you will need to know what the limbs of Pemsel's case are, you don't need to know the specific rules about how they might apply in certain situations or categories. So you'll need to know this stuff for your exam. And historically, what Nicola and Tom have done is to take factual situations that very much align with cases that are in your subject outline, subject, the case list, or whatever the document is that is published on the JCU. They take those little factual situations, and often they'll either sticky tape two of them together, or they'll change one important fact in those scenarios. So you have to be able to demonstrate your knowledge of the underlying subject stuff in order to answer those things fully. Right. So this, again, I'm going to probably not go for the full 2 hours, I would think, in relation to this topic. But I'm going to talk about some of the cases, and I'll just go through some tips that we're going to have for the test. And for those that are in the shoots next week, I do recommend I'll certainly have more of a picture as to what's going to be in the thing. So I said, well, we can go over that in the shoots next week as well, if you like. All right. So this is essentially a recap. You'll find the material from last week, the material from this week. They kind of all sort of merge into each other. So I'm going to be recapping some things that we talked about last week and going on and doing some of these limbs in more depth. So you may or may not recall this case of the Commissioners of Special Purposes of Income Tax in Pemsel. It's in the late 1800s. That particular case was about the advancement of religion, I believe, some Catholic, some branch of Christianity in heathen nations overseas, and that went off to the House of Lords, and they looked at that question, and they, as part of this decision, went through and analysed these definitions of charity. They looked at these long-standing definitions of charitable purpose and essentially categorized them into 4 things. The first one is for the relief of poverty, age, and impotence. That's the first one. It's to advance the purposes of education. That's the second one. Advance the purposes of religion. That's the third. And the fourth one was kind of this catch-all. Things that benefit the community. So other purposes that in some way are beneficial to the community. And the Queensland Parliament, it must be relatively recently, because I do not recall when I studied this subject sort of 10 years ago, this particular additional limb being in there, which is this that in the state of Queensland, and only the state of Queensland, this doesn't apply, or at least not in the same way for the Commonwealth stuff, recreational and leisure time facilities. Okay, so leisure time and recreational facilities that increase social welfare Parliament has said counts as a charitable purpose. And for purposes of us, we are thinking particularly of trusts. So these days, well, I'll talk about the 4 limbs of pencil case, but it's really the 4 limbs plus the statutory one after it, because there'll be some of these cases where the common law, the rules of common law and equity, would actually suggest that isn't going to be a charitable purpose. Parliament's jumped in and said, yeah, it's going to be. So we're going to go through that. Now, just another thing to note as well, I was going through with various class tests, and there's the term public benefit, which is thrown around. That's a category, and I explained that last week in terms of where that sits. But I've just noticed in terms of the test, they've used the term public purpose. There's 2 distinct and separate things. All right, and so the way I have categorized this material is you have the test of public benefit, and this will intersect with these things, but the limbs of Pimsl's case, plus the 5th one, I'll refer to here as charitable purposes. And you might see in some of the textbooks, because I went through the 2 prescribed textbooks and had a look, and they have described this, the term public purpose, in slightly different ways. And again, going back and looking at the previous year tests where the phrase public purpose is used, if you do see that phrase in your test, it means the test in Compton and Oppenheim's case. That is specifically what that term is used in relation to your test. So just make note of that. When you are looking at it, if it does appear in your test, and as I said, I have no idea whether it will or won't, but if you see the phrase public purpose, specifically they mean the test in Compton and Oppenheim's case. That is the idea that in order to be beneficial for the public, it can't have a particular quality that is in some way associated with the set law. So you can't just have, for the benefits of things that have a public benefit, they can't have something saying, oh, this is for the public, but only people who are related to me in some way, or only my employees. That's not going to be to the benefit of the public if people can't sign up to that thing. And so the 2 examples are those related by blood and those related through employment. Oppenheim's case involved British and American tobacco. And they had said, in that situation, anybody who was an employee, a former employee, or relatives or dependents of former employees or current employees. Pretty big list. It was a very big list. Had 110,000 people in that list. Still not beneficial to the public, even though the class of persons was large, because they were connected by a particular quality and other people couldn't sign up to that. You can't just knock up to British and American tobacco and say, I would like to be an employee. You can't do that. So just make note, that expression, if it does come up in your test, that I'm not too sure whether it was Nicola or Tom, is referred to that as public purpose. One of the textbooks uses that term, the other one doesn't. It's essentially a subset of the public benefit rule. Things must be beneficial to the public more broadly. Okay. Right. So what are we going to do for this lot is to basically just go through each of these 4 limbs of Pimsl case and just have a bit of a yarn about some of the cases and how they operate. Essentially, here's the rule, the high-level rule, and we're going to look at each of those things and the sub-rules that essentially makes up this high-level principle. All right, so we'll start with the first one. The poor, the aged, and the impotent. And I appreciate with this stuff, we're doing trust law. It's old school language. You're not dealing with contemporary 21st century English. So some things to note. The first thing is that is disjunctive. A person does not have to be poor and aged and impotent, even though often they'll overlap. You can have people who are old and are poor. LaCroix, I believe I talked about that last week. because that comes up in a variety of situations. There, it was a private hospital that would do things like look after people. Even though it was a private hospital, they would still take on people who didn't have any money, and the proceeds of that hospital would go back into the to other purposes as well, in terms of other purpose beneficial to the community. And in situations where the public hospital had an overflow, they would take patients on as well. LaCroix was also the case citation because the amount that was put to it was for 200 years, that charitable trusts don't care about the rule against perpetuities. They don't care. They don't have to vest within 80 years. Okay. So we've got essentially the 4 limbs of pencil case. The first limb has got 3 different categories, and sadly, some of the rules operate differently in regards to those 3 things: poor, aged, and impotent. And there's a bit of judicial commentary which goes either way. A lot of these things have a little bit of ambiguity in terms of how they apply. So the first one, though, this idea of being poor or poverty, a couple of things to note. The first is that we in Australia live, and are very much aware, we live in a wealthy country. This is a wealthy country, and if anybody thinks otherwise, they need to travel more. I, as a New Zealander, have come to Australia. I very much notice the difference in wealth between those 2 nations. And when we are looking at this definition of poverty, we're actually looking at it in relation to the Australian standard, the Australian norm. So being poor in Australia, which, if we looked at that globally, a poor person in Australia is vastly better off than 95% of the world's population. But nonetheless, that is the test that is used. I mean, it's taken from the UK, where poorer people in theory are probably worse off objectively than they are here. And so there's a couple of phrases they use. This one from Ray Coldheart, they use the phrase, it's being poor or being in poverty is for those, or it's for the relief of those who go short a little bit in life, who have to do without. And in terms of, I guess, an objective standard, it's a modest standard of living. And that's a modern standard of living in Australia. If you can't meet modest standards of living in Australia, then in terms of the first limbs of pencil's case, you can count as being poor. Okay, and this Alice Springs Town Council and the, I'm going to pronounce this wrong, Mweteyere? It's one of the indigenous corporations anyway, in the Northern Territory. And they had set up workmen camps in and around Alice Springs. And the reason this case came up, it's a Northern Territory case, was to do with the paying of rates. I think I'd listed this case a few weeks ago as the example of when we were talking about charitable trusts. What are the benefits of a charitable trust? One of them is that you're supposed to be, most jurisdictions, exempt from rates, from council rates. And so this was the case. I think I talked about the Alice Springs case. It's this one. This is the full citation. And they set up these, I said, workmen's huts, with the aim of taking care of indigenous peoples in and around the area. Now, one of the problem is that the way the thing was established, I'm not sure what the year was, I think it's quite recent, about 20 years ago. It was supposed to be for people of particular indigenous affiliation. And so the Alice Springs Town Council was like, well, we don't think, given the way that these tests work, we're not convinced that that's of benefit to the public more broadly. Now, I mentioned this briefly last week, and it's on the next slide as well. In regards to the relief of poverty, it can be said that the public benefit test does not apply. I say that with just a little bit of trepidance because there is some dicta that does say you still can't just give it to your relatives. Other places it says, well, you probably could, assuming that you expressed it broadly enough. So the first limb of Pemsl's case has these three components. And the first one, the relief of poverty, arguably doesn't have a public benefit component. You can say all of the poor people of Latrobe Close, even if there's one poor person in there. But some of the cases also say, it couldn't say, my poor auntie who happens to live in Latrobe Close. That probably wouldn't be acceptable, even though strictly speaking it's not, arguably doesn't have this public benefit test. Okay. Now, that rule about the public benefit test not being strictly applied to poor, it doesn't necessarily apply to the other two categories, aged and impotent, which we'll talk about in the next slide. All right. Now, when we're trying to determine whether somebody's poor, if someone has a full-time job being paid minimum wage in Australia, can they be poor? And this has gone backwards and forwards between the courts in the UK in regards to that. But appreciate, their minimum wage is nowhere near as high as ours. And so being poor, arguably, in Australia, you may have a hard time proving it if some person has 37.5 hours of paid work at the minimum wage. You'd have a real hard time proving that. And so this came up in these two cases. The first one was to do with funds that were allocated towards, again, ostensibly poor employees or former employees in regards to them going and doing recreational activities, holiday type activities. And they said, in this sort of circumstances, these people either have jobs or have had jobs. How can they be poor? That's essentially the argument that was being made in relation to that in Reed Drummond. If you have a job, probably can't really be poor, at least so the courts of common law believe anyway. So for policy reasons, we're not going to count it. You can still try and push it under one of the other limbs of Pemsl's case, but not this one. And most importantly, it means that the public benefit test is going to apply more strictly to the other ones. And kind of the opposite of that was found in this Nizaki's will trust. There some money was allocated for, I think again, workman huts. So basically having buildings that were established to look after the working poor in Cyprus. And the court in that situation said that, look, in this particular set of circumstances, even though we do say people in full-time work can't really be poor, first of all, purpose has been pushed to Cyprus, much minimum, no, don't even know if they had a minimum wage. What year is it? 78. Probably did. Cyprus, I believe, was still a British colony, actually, in the 70s. But anyway, any scholars of European history can correct me on that. Nick Xenophon, that's why this came up. The High Court's looked at it recently. And they said in that situation, look, the facts suggest you are dealing with people who are working, but their lives are quite miserable. They're working full time, their existence isn't great. Even though there is this presumption in this particular set of facts or circumstances, it's not going to apply. We reckon you can be working full time and still be considered poor. And that those sets of circumstances. Okay, I mentioned that this public benefit test probably doesn't strictly apply to relief of poverty. There's need to demonstrate that it goes across, and there is some arguments in situations where there have been, in some circumstances, situations where you can go and have poor employees or former employees in relation to the poverty test. They can go through and do this. But there is, unfortunately, this is one of the difficult things in law. You literally can make arguments either way in terms of whether or not it's going to meet this test of public benefit when it relates to people, whether it's this direct relationship and kinship and direct relationship in terms of employment. And relatively recent case, this is in the federal court, where you had the relief of poverty. So there was certainly the relief of poverty, but the entity that the money was given to, the charitable trust was being set up to, wasn't the one that was doing the actual relief. Because one of the key things to note here is that you have to actually be relieving poverty or relieving the aged or relieving the infirm, and that relief originally, again relatively recently, had to be done directly, had to be the same organisation. And so here, the full federal court said, no, that's gumph. That makes no sense in a contemporary commercial environment. You could quite readily do GoFundMe type arrangements where you're having one body that does the collecting of money, and then they send it on to other entities that do the actual relief of poverty part. They do the actual work. Sometimes these things can be commercial as well. Take a percentage and pass it on. But it's as they said that, look, this relief of poverty thing can be indirect. That's fine. Okay, now, this first limb, it has these three things: relief of poverty, care for the aged, and looking after the impotent. And the public benefit test is arguably low, possibly zero, in relation to looking after the poor, but that's not the case for the other two. So aged or impotent people who have an employment connection or a bloodline connection, kinship connection, you're going to have a much harder time demonstrating that it's going to fall under the first limb if it falls under those two categories. And where this came up is in things like retirement homes. They're big business these days. This side of the of the millennium, retirement homes are big business. They, you can kind of see why. Technology, medical and healthcare science means we're living a lot longer, working a lot older, but also living a lot longer. And as such, the need in society to have these sorts of entities is ballooned. So if you bought shares in retirement homes 20 years ago, you probably wouldn't need to be here because you'd all be retired. And so a couple of things that they've noted, these are relatively recent cases, so it's in the 80s, where there are homes or institutions that are established for looking after old people. They fall very cleanly into one of two categories. Are they for-profit things that distribute dividends and distributions to shareholders, or are they themselves, are their aims or objects to take any incidental profits and put it back towards those activities? So that the big retirement home providers that we have in Australia these days, they, assuming that they're for-profit entities, are unlikely to succeed in terms of being the recipient of a supposedly charitable trust. And that the last point I'd mentioned before is that quite often when we're thinking about people being old and being poor and being impotent, by impotent I just mean sickly. You've had accidents or illness that renders you incapable of leading a high quality life. there's a strong trend as you get older to not be able to do stuff. And so those two are often combined. They've got this overlap between them. And in terms of this first limb of pencils case, again, in terms of the public benefit component, it's arguable that it still applies in relation to that, and probably not for the relief of poverty. So these two are pretty much the same in regards to that. Okay. The next limb of Pemsl's case is to do with education. And I guess this particular one is closer to our hearts because a lot of these institutions here are things very similar to things that we have to deal with in and around the university. So a couple of things to note, both education and religion, those terms are construed really, really widely, very widely. And education is not limited to rocking up, doing things in classrooms, and just doing teaching and just doing research. It's far broader than that. It includes the whole experience. So if we think about universities in particular, what is the university experience? It's things involving stuff with the student association. And as both of those two cases, McMullen and Cairns have, these involved sports clubs. So money that was allocated ostensibly in a charitable trust towards the building and maintaining of soccer fields. And the first one, and the second one was the playing of, I think it was rugby union, the rugby union club at Sydney Uni. Yeah, Sydney Uni. Of course it was union, not league. Silly me. And so yeah, some of the discussion that comes with this is always a little bit colourful. Oh, if we don't allow students to have some let off their steam and all of that spare time that they have, the things, things will become heated, and it would tend to make them become barbaric in their well-being or their interaction with others. And I just remember looking at that thinking that, first of all, I think students back in the 1950s clearly had a lot more spare time. Most of you guys don't have a lot of spare time. I imagine most of you guys have to work outside of here to pay for your education to some extent. But nonetheless, this theme of sport being important is, it's a theme in Australian culture, first of all, even though McMullen's is a UK case. But the idea of that being integral to the university experience, as well as secondary school as well in terms of PE. But the student unions and sports and recreation stuff is very, very likely to fall within this category of advancing education. That is fine in terms of it being a charitable trust under the second limb of Pemsl's case. Okay, and Tom in the past has a habit of actually putting these things in exams, by the way. Putting those things. So the exam questions, if you look through some previous year ones, will probably have somebody giving money to a cricket club or something similar that was affiliated with a university. That's fine. Cairns. Specialist fields. Okay, again, if you go through some of the text, when I was going through the Del Pont text, and he's gone through and listed like 20 different fields, law and education. When I think education, the field of learning education, engineering, medicine, and so on. So having a particular purpose, which is to advance a particular discipline, is fine. You can leave money in charitable trusts. I'm not sure what the status is, but the Cullinane Fund, Karen Cullinane, when he retired back in 2011, before Justice North became the Northern Judge, created a trust with a large sum of money, and it is put towards the benefit of law James Cook University. And I'm quietly confident that that trust doesn't pay tax. Okay. Now, this case at the bottom one, I think I should talk about. Rhys Shaw. So there was a gentleman, a very colourful gentleman, a playwright called George Bernard Shaw. And as well as being a colourful character and a brilliant mind, he, perhaps tongue-in-cheek, to possibly mess with the heads of a bunch of lawyers who would be dealing with this problem for years after he died, he put some quite complex things into his will. I suspect that he knew what he was doing. He wasn't. There was an aspect of playfulness that came with this. But so there's actually a couple of cases involving George Bernard Shaw and his widow as well. But this is the one involving him, because one of the things that he put in his will was for a packet of money to be put in ostensibly in a charitable trust for the purposes of creating a 40-character phonetic alphabet, as you do. So he wanted to have the purpose, express purpose, of creating this 40-character alphabet, and if it turned out to be awesome, probably didn't use that exact word, but if it turned out to be to have great utility, to then, using the same funds, petition the UK Parliament to change the law to make that the law of the land, or something along those lines, to push to make sure you give it common acceptance. And so the courts had to look at a bunch of these things. The first one was to do with, look, is this, strictly speaking, the advancement of education? And they talked about this in a bit of depth, because research is construed in really broad terms, but research has still got to have a public benefit of some sort. And the way this thing had been construed was that the researcher was supposed to go do this work, then if it was found out to be interesting or useful or would add a great deal of value, then go and petition the government. And that didn't really count, at least that first component, as truly falling within the umbrella of the second limb of Pemsl's case. It wasn't sufficiently public in terms of the research, in terms of benefiting humankind. And this second part was efforts to change the law. That's a political purpose. And political purposes cannot be charitable in common law and equity. So that's how that was construed. Now, the reason why I've talked about this, it's really the third point from Rhys Shaw's, which is this harmful occupations, is that the judges, when analysing this, also said that when you're looking and determining whether something falls within this category of education, advancing a particular discipline, some disciplines don't count. An institution, for example, that encourages, I think the two examples were pickpocketing and prostitution. So if you set up a school to do either of those things, they were deemed, again, the term they used was harmful. They would not count as being charitable. So education which is pushed towards particular types of fields that are not beneficial to society cannot be charitable within that meaning of the second limb of Pemsl's case.
Would that still be the case in, say, Queensland where prostitution is legalised? Would it still be?
Possibly. It would depend how such a school was set up. Because, again, Parliament can do whatever it likes. And so, for example, gambling. There's a statutory framework that says we can have a casino. prostitution. There's a statutory framework that says we can have prostitution. At common law, those things are considered to be against public policy. And so when Parliament jumps in, creates the stat frameworks, they would have to set up the stat framework to create the particular educational component of those. Parliament's probably not going to create a school of professional gambling and a school of professional prostitution. They might do. I wouldn't hold your breath. If those things happen, though, then yes, equity will follow the law. But until Parliament jumps in and does that, you would follow the common law policy, which would follow what the judges said here in Reshaw. Strictly speaking, it's obiter. But that would, in my humble opinion, that would be the way that would be construed now if this came through the courts. Yeah. All right. So what things count as research? What things count as research here? Well, clearly, a university that sets up, I don't know, what are those buildings over there? You notice that this institution cleanly divides itself into the sciencey ones that seem to do really good, useful things for the world, and the non-sciencey ones on this side, and the river divides the two. So we are a west of the bridge discipline. We don't really add much to the world in terms of our research, ostensibly. They're supposed to add all of the value. But in terms of the limbs of Pemsl's case, they're not going to make that sort of distinction. Research is research. We're not going to make too much of a value judgment on the quality of research, largely because the quality of research is something which is done by one's academic peers. If research is done and other academics say this is gump, that's not real research, well, then it's probably not going to fall within the limbs of this, because that's the accepted way we would go about looking at whether this is research. But if you have reached this point where you can, you're enrolled or admitted to a PhD course in a university, even if it's on, this perhaps is a bit mean, the differences in spinning wheels in Southeast Asia, or I've got to be really careful with this. I can't do derogatory things, because I'm perfectly happy that if I was to say something derogatory about hospitality and tourism, they could very easily say something derogatory about the law and legal research. So there are some disciplines which perhaps other disciplines don't respect as much as other ones do. That does come up. At the end of the day, we accept that these people have jumped through the hoops in a structured university environment to get the boxes ticked off to engage into that task. And this is very rich for me, who, for my own research, is doing essentially applied sociology, which may or may not exist. Okay, and so just make note, we've got this idea of something that people identify as research. The charitable trust can be set up with particular narrow research in mind. And again, as long as it's going to fall within that category. And again, this is a legal problem. Sometimes these things are going to have some practical problems. And at the end of this lecture, I'll talk about the CPRE doctrine that can solve practical problems. But from a legal perspective, the courts aren't going to make a value judgment as to how useful a particular research is, just as long as it's commonly accepted that this is an area and this is a discipline. So I said Reece Simpson was, I think it was actually Justice Gibbs when he was in the Queensland courts, went through and talked about this, and he said that, yeah, giving money specifically for cancer, that's fine. That's fine. It's absolutely fine. You can be as specific as you like. But in common law and equity, as I've mentioned with Reshaw, it is not charitable if it is political. And doing things for purposes with something involving the student union or student association, for them to go and petition the federal or state governments or councils to change things, will not be charitable under the second limb of Pemsl's case. And that's mapped out and the Charities Act as well have gone through and took that. I think I explained last week a little bit about this interaction between the state and federal law. I'll talk about it a bit more at the end of this lecture, but that idea that trust law is state law. And so when we are dealing with trusts, we must use the limbs of PEMSL's case, notwithstanding that for a variety of federal statutes, they've got many, many more different types of categories of charitable purposes. We don't care, because we're trying to determine here whether or not a trust actually exists. And we must satisfy one of the limbs of PEMSL's for that to happen. Okay, and make note when doing this research step or this research process that education doesn't have to be teaching related, and it doesn't have to be definitely doesn't have to be teaching related. It can be research related, and it can also be research related if it's adding value to the researcher themselves. So in this case here, this is the Ree Hopkins Will Trust. This is about a trust that was set up for money to be allocated for people to try and research whether or not all of Shakespeare's plays were written by Sir Francis Bacon. That was the purpose of this thing. And the English court said that's actually okay. Not because the results of this research are going to be published. Right? That's not really the key thing here. It's more that the process of doing it is going to add value to the researcher, and the researcher will subsequently go and communicate this benefit to the world. So the research itself doesn't have to be directly communicated. The process can add value to the researcher. And from time to time, research can be done. You get to the end and you go, oh, no, we didn't find anything. Or worse, got to the end and we failed our ethics application. Something along those lines. The research can't be published to the world. That's okay, provided the people that were involved benefit from it and they carry on doing other sorts of research and communicate that to the world. That'll satisfy the public benefit component for the second limb of PEMSL's in relation to research, where it's not directly published. That's okay. Art's not really, strictly speaking, educational, but the courts have said, look, it can be, provided it's narrowed. And again, you've got the process, art, which is going to be involved, so put things towards art, where there's a teaching component to it. You're actually going and taking people and teaching them how to do it. That's easy. That's easily going to fall under the second limb. If you've had money left in a charitable trust towards art broadly, in the broad sense, hey, go out and do artistic things, that's not going to fall within the second limb of PEMSL's case, but it can do if it's specific enough. And again, that aligns back with the Ree Hopkins case as well. The people going through doing the art, there can be an education component to this, provided again that carries on and is broadcast to the world. But it has to be specific in how it's established in that particular instrument. Okay, next one. I'm about to flick over. We'll do the one. It's probably a good idea to take a break. We'll take 5 minutes. We're probably going to finish this early. Although we've got to shoot after this class, so it's kind of moot, really. Take 5 minutes now anyway. I need to get some water. And so I'll put this on pause, and I'll see you guys at about 5:02. religion. The third limb of Pemsl's case, much like education, is construed really, really, really wide. The courts, as you could imagine, don't really want to delve too much into what a religion actually is. Now, the payroll tax case, it's possible you guys have actually been exposed to this in your first year. It's from the early 80s, and it involves the Scientologists. So the Scientologists were assessed for payroll tax in Victoria, and they wanted to argue that they were a religion, therefore exempt. And the Commissioner of Payroll Tax said, don't be ridiculous. You guys believe in the writings of, was it E.F. Hubbard, I think his name is? And there's a whole bunch of, hang on, better preface this. Are there any Scientologists in this room? Okay. They have, who was a science fiction author, and they had a variety of, some might argue, to be rather unusual or strange beliefs about the creation of the universe and people and what they ought to do. And there's a movie, a terrible movie called, I think it's Battlefield Earth, from about 20 years ago with John Travolta. Anyway, it's an appallingly bad film. And I just thought it was just a terrible film. And it turns out it's actually based on the tenets of Scientology. Anyway, they rocked up to the High Court and pleaded their case. Hey, we are a religion. And the High Court said, look, previously, the courts, for a long time, hundreds of years, had really looked at the underlying sort of truth or belief of religions. Is there some aspect of believing in the divine? And the courts would go through and look at that and look at the wrongfulness and rightfulness of those things. And fundamentally, this took a really long time, this is the 80s, they said fundamentally that's flawed. That's completely not the way we can go about determining whether something actually is religious, because almost by definition, you can't adduce evidence of the truthfulness of your faith. All religions think they're the one true faith. We can't test that. It's not capable of being tested in the courts. And so fundamentally, that fails as a test. You can't use that as a test of law. And so what we have to do is an objective determination of all of the indicia of organized religion. And that is looking at essentially these three areas, whether or not there are particular rituals or things that people do in the scope of this particular religion or religious activities, whether or not there are particular texts or rules or canons of that particular faith, and whether or not there are followers. Religion with one person in it is not a religion. In fact, a great deal of trepidation suggested that a religion has to have at least one religious leader and 2 followers. So therefore, the minimum size of any religion is going to be 3. And that was essentially accepted. That's the accepted law, and it's still the law to this day. And so I'm not too sure where the Pastafarians are at with taking their case up to the High Court. I'm not sure, but certainly it's not something the courts can go through and really delve into, whether or not what you're doing is true, whether or not you're doing it with a real and genuine belief in what you're doing. It's about the objective stuff that we can see. It's a bit like in the criminal law when we try and look at the person's intent. We're trying to think of intent. We can't actually think what's actually going on inside their heads. We can only look at facts in the world, and that's the way we're going to do it. Because that earlier case, an English case, the United Grand Lodge of Ancient Free and Accepted Masons, Freemasons weren't a religion by the standards for the test that in the UK they'd used about 40 years previously, because the Freemasons didn't have a quasi-spiritual belief in stuff. They were just wanting to advance society in some way, encouraging this masonry, whatever it is, in terms of their this vocational type of training as their society. Didn't count. Okay, the YMCA. Is that a religious body? Well, yeah. It's heads bobbing around the room. Look, it's not strictly speaking a religious body itself. YMCA, though, does advance the purposes and aims of Christianity. And so that is sufficient. Giving money to the YMCA is going to be sufficient to fall within this really wide scope of what it is to be religious. And again, it goes back to the was it Watch Aid or the hunger case from the previous few slides, where they said, look, doing things to advance one of these limbs doesn't have to be direct. You can give the money to one group and they can go and do other things. That is okay. In Neville Estates in Madden, it was funds advanced to the building and erecting of a synagogue. And again, they talked about the need to do things directly or indirectly. This is a purpose that tangentially advances religion. That is okay. The test for religion under the third limb of Pemsl's case still has the public benefit test. And this is shown in the situations where people leave money to deal with and tend with graveyards and crypts. And it's a pretty simple idea. If it is a public graveyard, anybody can be buried there, that's going to be fine. If it is a private crypt or a family crypt, that will not be fine. So it clearly delineates between those two things. If it passes the public benefit test, if it's for the benefit of everyone, if anybody can be buried there, and if they can't, then it won't be. Okay, some of the stuff sort of requires the recapping of stuff from last week. But just a key thing to note is that this public benefit test is actually assumed. It's actually a rebuttable presumption when things are pushed towards religious organizations. It is presumed if an organization is deemed, again under the Commissioner of Payroll Tax case, to be a religious organization, it is presumed that that organization is established for the public benefit. And that the purposes they do go back into the public. So that's a rebuttable presumption. So just make note of that. It's the sort of thing that can come up sort of in assessments, the sort of thing that's worth a half mark or a mark to just go through and mention. Okay. Now, this IRC in badly often gets assessed as well. The reason for that is that it has two parts to it. And I'll see if I can remember these towns right. There was a charity, which ostensibly, some money left, ostensibly into a charitable trust that was for the benefit of people in West Ham and in Sunderland. Not sure what their second town was. It was two towns anyway in England. That's a shire. It's not even a town. I'm not sure. I have to go check the other one. West Ham is one of them. So two towns. All right. And that's fine. It's got a geographic location. Sure. Which is, we're looking here at the public benefit. But only those who were Methodists in those two towns or were seeking to become Methodists in those two towns. And the courts looked at this. They looked at the geographic location and said that's fine in terms of the public benefit component. Public benefit component, that's going to be fine in terms of the geographic component. But interestingly, in terms of placing this thing in this category of Methodists or not Methodists, actually didn't succeed in terms of the public benefit test because it essentially restricted people being able to access this trust or trust funds to those that were of a particular group. So that's IRC and badly. I talk about that. The geographic location can be fine. Two towns is fine. But this secondary clause was not going to be. And in those situations, what do the courts do? Usually they just remove the other clause. They just remove it. That's in the final slide. All right. I also talked about these two cases here in terms of the public benefit for religious test, which is the Gilmer and Coates and Crowther and Brophy. Coates actually has an E. It looks like a typo. The first one was a group of nuns, 20 nuns in a cloister, so a shut-off monastery in Notting Hill, and they were praying for the benefit of all personkind. That was held to not satisfy the public benefit test because there's no way of telling whether or not your prayers will actually benefit all of personkind. That's not capable of being assessed by the courts. Has anyone ever taken the number 16 tram in Melbourne? Bit of a way out there question. Tram goes from St Kilda all the way up to Kew. I've taken that tram many times, and it passes through the suburb of Hawthorn. And so, travelling from Hawthorn to Kew, which is what Crowther and Brophy was about. There were two churches, and I remember walking past. Now that I think about it, actually, I know the exact church. I remember walking past it with a full moon and the bats from Yarra Bend were going past. So you've got one of those like gothic horror moments going past this old church with a full moon and all the bats. Anyway, Crowther and Brophy involved the two churches, one in Hawthorn, one in Kew, and they the money was left for the priests to do mass, do public mass, and do prayers in that mass for their three sisters, I think it was, dead siblings. And the amount that was going to be paid was something absurdly small. It was like $5. And the amount that was left was something absurdly large, like $800,000. And the priest there said, no, this is dumb. We're not going to do it. And they, anyway, this thing trotted off to the Victorian Supreme Court. They had to go and analyse it. And they're looking at this, whether or not the trust is just going to fail. Because you can appreciate when people are rocking up to court, if you were the assuming the settlor is now deceased, or was a testamentary trust, if you were the residual beneficiary of that estate, what do you want to happen? You want this to be struck down as failing the third limb of pencils. Therefore, it's not a valid charitable trust. Therefore, it's in this situation, it's not going to be a gift. It's going to result back to the settlor. If it results back to the settlor, the executor has to then give it to you. Okay, and just to make another note too, and the reason I'm bringing this up is that Tom labours the point, this distinction between executors and trustees may have come up in previous year tests, might be worth noting, but one of those things that has come up when people are talking about resulting trust back to the settlor, essentially if the settlor has long since died, the executor still has to follow the instructions in the will or the rules of intestacy in the Succession Act in order to apply that money to those that would otherwise have got it. And so the executor's duties are for life. Even if they've given all of the property out and they think they're finished, if more property somehow comes back into their hands that belonged to the deceased person, and that can happen with a resulting trust. So if something like here, like a charitable trust, would fail and it results back, then the executor is going to have to dust off the notes they have for this and come out of retirement and make sure that that property goes back to the right beneficiaries under the will. Which actually wasn't what happened here because they used what's called the Cypre doctrine, which is in a few more slides. All right, also just make note that Gilmer and Coates would probably not happen, or at least wouldn't be done the same way in regards to Commonwealth stuff because of the way the Charities Act is structured. They actually say, for the purposes of Commonwealth legislation, closed or cloistered monastic groups that do let people in from time to time are going to be fine in terms of charities under that. Do we care? Not really, because trust law is state law. We are still following the limbs of Pemsl's case. And if you can't succeed in the third limbs of Pemsl's case, not a charitable trust. It's not going to be a trust. And again, you'll have to construe it either as a gift or resulting back to the set law. Okay, the fourth limb, the open-ended one. Well, it's not open-ended like we would analyze something in stat interpretation. You guys remember the justum generis rule, where you've got a list of items followed by an open-ended class. The makeup of items in that class is restricted to the items before it. That's the justum generis rule. Of course, you guys will remember that because you've got all your stat interpretation stuff in your brains. All of those eager souls are going to be doing trust accounts probably with me next year. Got to remember, dust off your rules of stat interpretation. Okay, and it's an objective test. So it's the courts will look at what would a reasonable person think in regards to this, whether things are otherwise beneficial to the community. The National National Anti-Vivisection Society case is one worth noting. I haven't looked, but I'm 99.9% sure it'll be in your case list for this subject, and I'll talk about it. Why not? Okay, so National Anti-Vivisection Society, as you could imagine, didn't want animals to be chopped up in the process of doing medical research. Okay? Fine. That fundamentally, though, you're wanting to go through and change the law is a political purpose. So wanting to change the law is going to be political. People get stuck on that, by the way, in the examination type situations in this subject. Just make note. So Reshaw, in the previous, about 4 slides ago, read George Bernard Shaw and also the National Anti-Vivisection Society. It's something that's important to note. Changing the law is political, or trying to change the law. It can't be charitable, at least for trust law anyway. And they trotted up to court to argue that they were charitable in their nature and that they, as part of what they were trying to do, this was their argument, was to make human beings more moral. So if you try to reduce the amount of suffering in animals, the argument here is that it makes us better people. And that, so the argument goes, is beneficial to the community. Again, they're trying to do this under the fourth limbs of Pemsl's case. And this is much higher, harder, firmer public benefit test. You've got to demonstrate a tangible benefit to society. And what the court said there is that, well, strictly speaking, you're right. But the way this test works is that we, the court, are going to take into account, when you're determining whether or not you're going to fall under this limb, the good things that comes from your particular activities or aims, and the bad things. What are the bad things about stopping medical research? Well, the whole point of doing medical research is to advance the knowledge of people in order to save people from dying. And the key takeaway from this, by the way, is that charitable trusts are not for the benefit of people, and they're not for the benefit of the environment. In 1891, when Pemsl's case was on, neither of those things mattered. And it's important because trust law is rooted in this deep-seated, long-standing, old-school series of rules. And if we stop and think about trusts themselves, kind of as Benedict Atkinson refers to them, they're just a vessel for evasion. These are old school rules. You guys get a competitive advantage over other people in society by knowing these rules. And that idea that trusts are about people is actually core to what we're doing here. And so there, the courts and the National Anti-Vivisection Society said, look, we're going to weigh this up. We're going to weigh up, yes, people are going to become more moral. Yes, fair enough, good argument. But people are also going to lose out because we're not going to be able to do medical research on these animals. We're not going to get all these new cures and medicines and so on. And on balance, this one's more important than this one. And so that is one of the reasons why they didn't get up. And so that when examining this, the court is going to weigh the benefits, the pros and the cons, to determine whether or not you can fall under this fourth limb. Because this fourth limb is deliberately expressed in very broad terms. It is, when I say other purposes beneficial to the community, I mean, by default, by the way, that has a public benefit test. You've got to prove it's for the community. And in the law reporter's case, they argued that the production of the law reports, I'm not sure which state, it's Queensland law reports, it's in the name. They argued that the creation of law reports was beneficial to the community. And you would have to sort of think about this for a second. These bodies that are set up, they are usually not for profits. They're usually incorporated associations, and they have a specific aims and purpose. And often, the funds for something like this go towards other associations, probably the Queensland Law Society or its predecessor. And here, they argued that in creating and doing all of the reporting for all of the cases in Queensland, publishing them, giving them to lawyers, and only lawyers, and barristers and judges, that was going to create a tangible benefit to society. Those lawyers and judges and barristers are going to be able to go off and help more people. And they got up. That's fine. Yes, we accept that actually does increase social utility in regards to freeing up lawyers, freeing up their time to do more good in the world. I did TCLS yesterday, quietly confident I'm not doing much good for the world. All right. So what things are going to be by default good for the community? Building stuff. This is the easy stuff. Building highways, repairing bridges, building roads, public works, things that everybody can benefit from. That is easy. That's going to be the easier because it's tangible. You can see it. You can see the result. And provided that it is strictly open to the public benefit test here is construed very strictly. Right, it's open to the public. It's going to be fine. The fourth limb, Pemsel's case, the public benefit test is construed strictly. It has to be open to the broad public. Okay. This case comes up in the assessment a lot too, eh? Relief of cyclone victims. And so this, we live in a cyclone area, and as such, from time to time, the city can suffer lots of damage. And so funds that are set up for the relief of that are fine, provided the gifts aren't tied in some way. It's generally going towards people for the benefit of cyclone or natural disaster relief. And that's what happened in this Marie Darwin Cyclone Tracy Relief Fund, because there was some money and it was put in, and then sort of 5 years later, they're like, oh, okay, what do we do with this money now? It's one of those nice things about trust law, particularly from next week's lecture onwards. It's like the mirror, it's the polar opposite of tort. In tort, there's a loss. We're trying to allocate where the loss goes. In trusts, there is property, there's stuff. We're trying to allocate who it goes to. And so here, these are all the good cases. Hey, we've got a big pot of money. Who's going to get it? So that, in that situation, that they can use what's called the Cypre doctrine in situations where they can't give it out to people. In the Cyclone Tracy, we can just put it towards disaster relief and for other disasters that come up. That last point there, that this, again, provided you've strictly complied with the public benefit component, you can put money towards social and moral development of the community. Social activities, things which have a difficult to measure tangible benefit. So people coming up, having festivals, having musical type events, these things that have a one-off investment, but it's very difficult to measure. That's fine, again, but the public benefit test is construed strictly. It must have some benefit, but it must be public. I talked about the National Anti-Vivisection Society, but there's some other cases here as well. And again, these have a habit of popping up in exams from time to time. This Green, this involved conservation. So having a park and having money allocated to fence off an area to preserve it. What's the problem with that? Well, as I'd mentioned earlier, trusts are about people. They're people-centric things. And the benefit in a completely fenced-off area is great for the animals and wildlife, flora and fauna that are protected inside that area, but absolutely nil for those outside. At least in terms of what the courts in 1970 could ascertain. And that's still the law. That's still the way that trusts operate here. If you have a fenced-off area for the purpose of conserving a big block of land, that stuff is not going to get up. It's not. You can get around this pretty easily by having the occasional public tour of that same fenced-off area. That's going to be fine, provided the public can get to it. People can be involved with this in some way. And there has to be, though, some actual use or utility here. This RSPCA New South Wales and Benevolent Society involved ostensibly a charitable trust that was established for 2 properties in Manly, and the testator wanted them to be used as a bird sanctuary. Trust, strictly speaking, for the protection of animals is really not going to be a trust. But they did go through and argue, well, these things could be set up, there's an appropriate amount of funds, people could come in and they could look at them and use these things. Could come in and wander backwards and forwards. So that aspect might be satisfied. The trouble was they got an expert to come in and look at this, look at the particular houses in the particular suburbs and said, well, there aren't any special birds here. It's just pigeons. It doesn't make any sense. It's complete nonsense that you would set these things up for the preservation of pigeons that live in urban areas. It didn't make any sense in that case. And so that essentially becomes a practical problem. Now, we are in Queensland, and we operate under Queensland law, funnily enough, and trust law is state law. When you are determining whether something is or is not a charitable trust, it must fall under the limbs of Pemsel's case or the 5th statutory category. If it does not, we do not care what the federal government has done with the Charities Act, because it won't be a trust. won't be a charitable trust. Remember that charitable trust, the beneficiary principle, either has to be for beneficiaries or it has to be for charitable purpose. It's not a charitable purpose under 4 limbs of pencil case, or the 4+1 limbs. It ain't going to be a trust. Therefore, it doesn't really matter much that if you had a non-for-profit, like an incorporated society that advanced beneficial things for animals, it doesn't really matter from our perspective in terms of what we're doing here in this particular subject. But you do need to note that charities in the broader sense, in terms of federal legislation, can be charitable if they're preventing suffering to animals, or environmental things as well. And I don't know whether I've raved about this very much, but the Badley's case was the two towns, West Ham and the other town whose name I can't remember. And the thing with giving it to Methodists, or those wanting to become Methodists, one of the things they noted in relation to this particular fund that was set up, trying to get it under the 4th limb of Pemsl's case, is that this public benefit test, and again I've put public benefit and public purpose. Public benefit is essentially the umbrella term to describe things that are open to people in the public and has to have some benefit component to it. So things can be open to the public, but if it doesn't help them in any way, it can't be charitable. And public purpose is essentially a sub-rule of that. One of the terms, I'm not sure whether Tom or Nicola is the one who uses that term, one of them does, to describe the test in Recompton and Oppenheim's. So if that comes up in your assessment, that particular phrase is what they're using. One of the textbooks uses it, the other one doesn't. Just make note of that. Sorry, I'm not trying to be obtuse here. I'm really trying to help if that happens to come up in your assessment. But just make note that those tests are strictly applied. It's got a much higher bar. You just will not get up on the 4th level of Pemsl's case if there are some sort of categories where they have to be employees or former employees or some sort of kin relationships. It's not going to work. You're probably not going to get up. Yep. Well, they can limit it in terms of scope. So again, Badley's case was limiting it to 2 towns. They had 2 towns, and they said that, look, actually limiting it to those 2 towns can fall with this an ambit of being beneficial to the community. That's going to be fine. But if it was just the people of Latrobe Close and Douglas, probably wouldn't. It is a question of degree, but when they're analysing these things, the purpose is beneficial to the community. That's the key phrase that they're really looking at here. Who is the community that's going to be affected by that? And the amount of money and the type of property matters. If it is $25 million, the community, if that's construed as people from one subdivision, it's not going to get up. It's going to have to be broader than that. If it's a much smaller amount, it might do. But it probably wouldn't work if it's going to be just one street. That's going to be a little bit too narrow. And again, sometimes I have to throw my hands up in the air and say, how long is a piece of string in relation to these? It is up to the courts to determine these things in terms of literally as a question of law. It's not something we can easily go through and determine ourselves. And kind of annoyingly, these tests in terms of public benefit in the federal level, so if you're an incorporated association and you want to go and get checked, they will actually go as an administrative decision-making function and check you and actually say, okay, we've weighed up all of these factors and determined that you are, this satisfies the public benefit test. Here in trust law, we have to go and ask the Supreme Court of Queensland, which is much more expensive, much more difficult in terms of construing it. So that's the only thing that the takeaway that I have from that is it's difficult to determine who the community is. And again, they'll look at the size of the funds and what the particular purpose is doing for. Building of roads and bridges. Well, if this is built roads and bridges in one very, very small area, which is part of a much larger area, it might not get up. If it was building roads and bridges in something like Burdekin, where it's the same number of people as one subdivision in Douglas, but it's the whole community, that probably would be fine. That's how those things go about construing those. All right, the stat cat adds this fifth one. Again, it does have a public benefit test. My little mouse. Where are we there? So, there always been charitable provider assist in the provision of facilities for recreation and other leisure time occupation if the facilities are provided in the interest of social welfare. All right, and you can actually limit them by gender. So under this particular category, they do go through and let you do that, but it still has the public benefit test. This is relatively recent. I haven't gone to look to see what the case law is like in relation to the public benefit test, whether it would be the equivalent of the fourth limb or whether the courts would be a little bit more lenient and use the ones from the education and religion. I don't know. I'm interested to find out. It's possible that there aren't any cases. Again, this is relatively recent. This wasn't in here when I was studying this years ago. Maybe that's a task for future me to trot along and go and have a look. But nice thing from your guys' perspective is means you're not going to be assessed on it, which is nice. So that's that. So it just basically says, look, in situations where things are going to go to leisure time activities and the social welfare, just starting with the ordinary definition of that term, is really, really broad. And one of the key, I guess, takeaways from this, and it applies to the fourth limb as well, but most of them, it comes from the LaCroix case. And so LaCroix and Perpetual Trustees, LaCroix, LA-CRAS, LaCroix, is that one of the key mechanisms that you can succeed in terms of the public benefit test in regards to all of the limbs of pencil case, including the fifth statutory one as well, is taking pressure off the revenue. So if you have a charitable trust which goes towards things that the taxpayer is otherwise going to have to pick up, courts will bend over backwards to uphold that particular purpose as being charitable. They will bend over backwards if you can demonstrate that this is going to stop either the federal or state government for having to pay for stuff. And this is particularly relevant, though, for the first limb and the relief of poverty. That's why when we talk about this relief of poverty essentially having no public benefit tests, or if it does, a very, 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 very low bar. And that idea that if you are pouring money towards your poor, in theory, your poor uncle, in theory, you could establish that as a charity, even though they're directly related to you. And one of the things that comes out, or why this can be sort of manageable, is that if you've got a whole stack ton of money and your uncle is still poor and claiming Centrelink, being able to give them money means that the taxpayer is not having to pay them Centrelink. And so in that sort of situation, the courts are very, very lenient in relation to that stuff. All right. Other things about the federal statute. At the end of the day, in terms of federal exemptions, stuff can get up on a vastly wider variety of things. Many more categories, including the one that would fail the national vivisection case. Actually petitioning to change the law can be a charitable purpose under the federal legislation. We don't really care because we're doing trust law. But you can tuck that away in the back of your mind. It's possible, by the way, it's possible that Nicola might actually ask what's the difference between doing this as a trust as opposed to doing it as an incorporated society. It's possible, but not sure. But just make note that while changing the law can be charitable, giving money to political parties, not so much. Not so much. Putting them towards parties. All right. This is the last slide. Good job. Someone here speak French? Let's go to French. I'm probably pronouncing this wrong. I think it's Cypre. Cypre. I think. I'll get that confirmed. But just make note, this is a doctrine enshrined in Section 105 of the Trust Act that says if, for practical reasons and only practical reasons, a charitable purpose can't be fulfilled because of a practical fact to do with it. Originally, it used to be the courts. Now, you can apply, the trustees can do it directly because of Section 105. You used to have to go and ask the courts. You can apply that money towards a similar purpose. Say that again. If a charitable purpose cannot be fulfilled for practical reasons, and there's still trust property to be applied, you can use Section 105 to apply it to a different but related purpose. And so an example here is the relief so it was other purposes beneficial to the community. Here, taking money for a cyclone relief for a particular named cyclone, and if after you've done all this and done what you needed to do in terms of relieving that, everybody's happy, that town's been rebuilt, and you've still got money left for whatever reason. Again, this is to do with practical problems, not legal ones. It will not cure legal defects to do with whether a particular purpose is charitable, whether or not it fails the public benefit test, whether or not it doesn't fall under one of the 4+1 limbs from Pemsl's case. If it is a practical consideration, we can't find any people left over who need money because they're homeless after Cyclone Tracy. What do we do now? And the courts are not the destroyers of trusts, and for a long time they've allowed applications to the court for that purpose to carry on being fulfilled by just tweaking it slightly. What would be an obvious one to do here? Put the money towards relief of the next big cyclone that comes in, be it in Darwin or elsewhere. So a fund, I don't know, to repair people in North Queensland after Cyclone Larry, if there was money left over, that could have been put towards Yazzie. And after Yazzie, it could have been put towards possibly the rain event we had last year, which I don't even know how to... Last year? No, it was this year. Floods this year, maybe. Those are practical problems with giving the money out to fulfill a purpose. It cannot be a legal defect with the purpose itself. That's an important point to note, and it's the sort of thing that, that's... And so, practical problems include finding people to give stuff to, where things are written out on the instrument and that particular place or whatever like that, that all of the particular aims or objects of this have been fulfilled in that particular purpose. Repairing all of these buildings. Once the buildings are repaired, we've got money left over. We can apply that to a similar purpose, repairing some other buildings. That is okay. That is the Cypre doctrine. If the purpose would fail because it hasn't been clearly defined, because it doesn't have public benefit, or there's some other legal problem. For example, the trust hasn't been properly constituted. These are all legal problems. The CPRE doctrine cannot resolve those. Other mechanisms in trust law will determine what happens, and usually that's in terms of things being improperly constituted, whether or not things are going to go out because they were intended otherwise to be gifts, or a specific purpose was made, and for whatever reason there's a defect, it'll result back to set law. Quistclose, Bucker's making Quistclose style situation. Is that clear as mud in relation to that? It's just the key thing to note. The CPRE doctrine will fix trust, because courts do not want to be the destroyer of these things, but it's only going to move it to a similar purpose. It's going to go back, read the instrument, determine what the settlor's intention was, and say, okay, this particular sum of money has been put to allocate for the preservation of Mount Stewart, so people can go bushwalking to look at possums. Sure. All the possums are now dead. Oh, sorry. There's a walk in the room. Walks in the room. What do we do now? Well, we could allocate that towards bushwalking tours to go and look at wallabies. Or, in another region, looking at possums up on the range, for example. That's the sort of practical problem that can be resolved. It would not be resolved if, for example, that same trust was applied to an area to fence it off so people couldn't get into it. That's going to fail the public benefit test. CPRE cannot apply. And I think we're going to leave it at that. I'll see you guys in Choo Soon.